but just be aware there's a massive change there. And one point I want to note on data breaches as well, there's kind of two main types of data breaches. One is the classic example, a hacker in Russia, taking a random country as an example, hacking into your systems and downloading all the data. That's one type of data breach. Another one, which is the most common one, is accidentally sending data to the wrong person, a misaddressed letter, wrong email address, that contains personal data, goes to the wrong person. That's a data breach. If it's it may need to be reported, so just be aware of that one. And then another change coming under GDPR is notifying affected data subjects. So if I use information relating to 100 beneficiaries, let's say, I might have to notify all those beneficiaries that I've lost their data. There's no obligation at the moment to do that, but there will be under GDPR. And the reason I've kind of put in, Facebook, Yahoo there, who've kind of been in the news recently, is can suffer big reputational damage. So I always advise my clients, there's three kind of ways you can fall down on GDPR. One is administrative fines, which I talked about at the start. That's a key one. The other one is massive reputational damage for a data breach, which can be more damaging. And the last one is litigation. Under the GDPR, you can now sue someone for both material and non-material damages. So what that means is, if there's a data breach, I'm an affected data subject, and I say, geez, I've suffered pain and suffering and I can't sleep at night because you've lost all my data, I can now, under the GDPR, sue that person and claim damages for my incredible stress and emotional damage. Can't do that at the moment under Ireland, under Irish case law. Collins and FDD is the Irish case on that. So that's going to be a big change on GDPR. Just be aware of those three big things. So this is the last thing is international data transfers. Just be aware of data leaving Europe at any point. One thing that I just remembered that I meant to say under data subject access request was, with restrictions, one of the questions, and maybe I'm saving off a question here, is, is there a carve out? If I as a trustee get a data subject access request, can I kind of say no, because it's beneficial, or because it's a trust and because it's a secret trust, I don't have to get that information. There is a law in Jersey and Guernsey that protects trustees from data subject access requests, but not in Ireland or the UK. Just be aware of that, and I kind of delved into that bit in my paper as well. But just on this point here, it's just if any personal data is leaving Europe, just be aware that there is certain steps that you go through to make sure that that's done correctly in the GDPR, which I won't go into now because that's a whole other talk and you've heard enough from me today. So I'll just leave you with a to-do list or kind of key takeaways, just generally, which might be handy going forward. Big one is accountability. Be able to demonstrate compliance if you're a data controller, and if you're advising a data controller, tell them that. Make sure you have the correct legal basis for consent or one of the other legal bases that I looked at. Update privacy notices and policies, so that's the principle of transparency, letting data subjects know. Bear in mind the rights of data subjects, which is, I think, the key one that we spoke about today. Be ready for data subject access requests coming in. Are you able to respond to that in 1 to 2? Do you have the process in place to gather all personal data and give it back to them within 1 month? Look at your contract with data processors. I'd recommend generally conducting an audit, which is just cleaning out all your data and making sure it's in a good place. Data security, we touched on, and prepare for data security breaches. So look, that's GDPR. Hopefully it's a little bit clearer. Again, I'm kind of tasked by Grania to solve problems. I don't know if I have, or created more, but hopefully we'll all be happier with GDPR going forward. Thanks.
Aileen, I might invite you back up if you don't mind, just to address any questions our audience might have. I think in fairness to Finín, it's quite an achievement to bring down, actually, will I give you this one together so that you can walk around, whichever. Sorry, it's quite an achievement to compress GDPR into bite-sized pieces, and in fairness to Finín, I think he did that. Also, as a committee, as I mentioned, we had, and obviously still do have, a concern about the ability of a beneficiary or a potential beneficiary to access information about a trust. And Finín has really helped us out with that in terms of going into the detail on it, showing us, the law in the area, particularly that recent UK case. And I think the point he makes is really well made. This right probably always existed, but GDPR is such a hot topic now, and there really is such an education around GDPR now, and it's in the media, and we're all talking about it. I think it increases the risk of beneficiaries perhaps looking for this kind of information. So we have Aileen and Finín here, both willing and able and ready to answer any questions you might have. Yep. Thank you.
Thank you. I just have a question for Finín. You mentioned earlier that obviously not obviously, but the data subject requests kind of die with you. Do legal personal representatives have any authority, or should I put it the other way, do any firms have any obligation to release data subject request material to a legal personal representative?
Good question, and very easy answer is no. Legal personal representative can't make a request on behalf of a deceased person, and no rights attached to a deceased individual, data protection rights. So I have come across it where a legal personal representative made a request on behalf of a deceased individual, very simple letter back saying a person is no longer a living individual, acts don't apply. Simple as that, which is good news, hopefully. See, I have solved the problem.
Not really.
No offence. Didn't I?
Oh. Project your voice, maybe. No
offence, Aileen, or Finín again. Just in context, 2012 put up a new computerized system. In doing so, put records as to name, address of one particular client who broke my heart 13 years ago in buying a house. And they only appear on the system now because I have their wills. I made a list, GDPR approaching, of the 5 people I expected to hear from. And she didn't disappoint. Last week I get an email, she's in HR, obviously she has just completed a course in GDPR. She wants all personal data of herself and her husband. And by way of personal data, she wants a copy of every item of correspondence on the file dealing with the purchase of her house. Now, touches on another issue. The file is 13 years old. It's in an unlisted box. Bloody well is now. 60 other boxes, whatever, that date from that time frame or whatever. I have the screen grab of all the information I have, personal information. I'm giving her that, but as far as the correspondence is concerned, no. But she is also entitled to a copy of her file, having grudgingly paid her bill 13 years ago. So, if I can find the file, she can get that, but that's just the personal information she's entitled to. Am I correct?
So, I've written down a couple of points at you. First of all, she's making an access request on behalf of her and her husband. She can't make it on behalf of her husband. The husband has to make his own request.
Oh, yes.
Yeah. And funnily enough, when you're responding to a data subject access request, you actually have to redact out every single other piece of personal data relating to any other individual.
Well, the personal information I'm going to give is a screen grab saying name, address, and I have a bit. That's it.
Okay.
That's good. Because when I put this individual's details on the system, I didn't go any further because if I never heard from her again, I wouldn't be very unhappy. I have. So in preparation of that, it suits me. I can just do the screen grab and show that is the personal information. No phone number, no email address, no sex, no nothing.
And then you mentioned, so the separate point then is she's requested a copy of her file. She's entitled to do that generally under kind of agency laws.
Yeah.
That's a separate point to data protection request, so she's entitled to copy of all of her file. You can take out internal notes and memos that you've done, prepared for your own purpose, but she's entitled to that. Now, you mentioned the correspondence, which I think is your main concern, that you don't want to go through.
Well, no, correspondence she can have as in letters.
Yeah.
The telephone memos and the discussion as to this person, no.
And would that contain personal data?
It would contain personal opinions on this individual. Not personal data.
So Aileen is making the great point here. Can you delete or shred and get rid of all this information? The answer to that is
hypothetically, yes.
well. Has she made the request?
She has made the request for correspondence.
So just to answer Aileen's point, and this is going back to the data retention point. If you delete if you haven't received a data subject access request and you go and shred everything and delete everything relating to someone, then the access request comes in. Nice and easy, go back to this. Look, I don't hold any information on you. If an access request comes in, you can't go to start deleting stuff, which I've thought about, but it would breach the fundamental principles of the GDPR, which I spoke about at the start. So if you've received it, as soon as you get a request in, they're entitled to a copy of all personal data that you hold. Now, just on that point as well, there's never any harm of opening a dialogue with someone who makes a data subject access request. They might say, give me a copy of all the information you hold of me. There's no harm getting involved in correspondence, going back to them and saying, is there something in particular you're looking for? Can we narrow it down to a particular year or a particular issue that you're involved in? And then that might save yourself a lot of hassle. Now sometimes, and possibly in your situation with disgruntled data subject, they might come back and say, no, I want it all, and that's fine. They're entitled to a copy of all their personal data. But for your own benefit and from a practical point of view, there's no harm in opening a dialogue with that person. So your point there is you've got memos that contain information about this that subject.
I have a record of phone conversations that I would have had with my colleague on the other side in relation to complaints, when we may have passed an opinion as to how much of a heartbreaker this person was.
I have bad news for you. She might be entitled to that information if it doesn't come under one of the exemptions. So the exemptions again are, can you exert legal privilege over it? You could try with an opinion expressed in confidence, but I've mentioned that that's quite hard to do in practice. And there's another one which I didn't mention on the slide, which is you don't have to, if there's a claim made against someone and you're discussing potential compensation that they might get for that claim, you don't have to give that information either. So that's stop the situation where there's litigation in being, and you've discussed, look, if she asks for 20 grand to settle it, we'll give her that. You don't have to give that information. So, but what you could do, from a practical point of view, you can always, and what happens in practice here, which is what a lot of people don't know, is, okay, let's say you provide that screen grab and a copy of her file, but there's these memos there now where you've maybe chatted with a colleague about her, potentially it sounds like it is personal data because it mentions her name and it talks about her. Let's say you withhold that back and just give her the screen grab and the memos and the copy of the file and hold back these memos. What's her next step then? A lot of people might ask. She would have to make a complaint to the Data Protection Commission, and if that's followed up, the Commissioner will ask for a copy of all the data you hold, including those memos, and then they'll make a determination on whether it's personal data or not. So, while not advising anything, some clients take a restrictive approach and some take a facilitative, and some might say, so you might say, look, I'm making a call in my head that that's an opinion expressed in confidence. I can rely on the exemption under the Act and I'm not giving it to her. Then data petitioner comes knocking on the door, boom, 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 show me all your data, and you kind of hold it, look, I genuinely felt that was opinion expressing confidence. That's the route you're taking. So in summary, it sounds like it is personal data. If you can't put it under one of the exemptions, they're entitled to a copy of it.
Okay, so a very practical example, thank you.
Sure.
Give this another go.
Yeah, this one's for Finín as well. Finín, I'm just curious, and I have to say this, GDPR, pretending it isn't happening, but obviously it is. But sometimes the data subject might not be a client of yours. I mean, Aileen mentioned earlier the trusts that you put in place for vulnerable people. And so sometimes clients will obviously express to you in confidence information about predatory individuals, perhaps, the reasons why they're putting property in trust for a particular individual. And it may involve information about the person's boyfriend or husband or friend. So you're getting personal data about a particular individual who isn't your client. And I'm just wondering, in that context, I saw in the exemptions it said you can rely on things like, protecting the vital interests of a person other than the data subject. I mean, can you rely on those things? I mean, first of all, I'm not sure how the person would come to ask you for the information, but if they did, can you rely on something like that?
Great question. So I suppose there's two parts to the question. Your last point there was what I was going to say. So a data controller can often take in information relating to other individuals, not be it a client. And to put out an example which I've come across is insurance companies. They might have a policyholder who's their client, but they might, investigate that client and realise, that individual, along with another 4 individuals, are putting in a fraudulent claim, and they might have the names then of those other 4 individuals. So your last point there is, it's in what situation would those? So first of all, the data controller is holding personal data on the other individuals. That is personal data. They're processing that data by holding it. So the acts apply. From a practical point of view, when will they really know that that is happening? And it would be unusual for someone to kind of come along randomly and just throw in a data subject access request. And then you mentioned, so it doesn't happen too much in practice, but it can happen, is what I'm trying to get across there. The other point you made then was, can you rely on vital interests? My short answer would be no. Vital interest is very difficult again to rely on as an exemption. Going back to my earlier point, you could just say, I'm of the view that this falls under a vital interest exemption. But in the long run, if it goes to a complaint to the Data Protection Commissioner, they will likely, and I'm just trying to give you what will happen ultimately, they will form the view that only in very limited circumstances could you rely on a vital interest exemption. So I'm just, do you have any practical examples then of, like, as in?
I can think of lots.
Yeah.
I mean, Aileen talked about the sort of predatory individuals. I mean, I've come across lots of situations where, again, just back to what this gentleman said, clients are giving you personal opinions in confidence about the character of a particular person and perhaps the way they're manipulating somebody and treating them.
And you rely on it being an opinion.
So it's,
So again, you could again an opinion expressing confidence on a particular subject. If it's done to a solicitor, we could try and rely on that.
A husband, a predatory type husband of a child who might be mentioned by the client would know that the parent, the mother in law, never hated him, so would be inclined to say there must be something there about me, so could easily put in a request.
And the request is going to, is it the solicitor or the trustee or?
Either.
Yeah.
because I like the Taylor Wesson thing, they would know, I mean, the law firm might be a barrier, effectively one of the barriers against these predatory type individuals is the law firm with the trust advising the trustees, so they might both be conceivably involved as data controllers.
Yeah, I mean, there's a legal advice privilege as well. You can exert.
It's opinion from the client to you, it's not legal advice, it's your opinion. I suppose if they're giving you opinions, but
Yeah,
give
it's
legal
information,
advice.
Yeah.
it's information clients have entrusted to you.
Exactly, so that's an
About
opinion
somebody else.
expressing, first of all, they're possibly looking for legal advice. Second of all, opinion expressing confidence. Those are their two go-to exemptions. Without really looking at it, it's hard to say whether it would fall in or not. There was another point.
Should we be then doing our attendance notes saying that in relation to all of this, an opinion was expressed by the client about A, B, and C, and we make sure that it's writing those words like an opinion was expressed or confidence was, so that we're covering ourselves for it, and then not comment about the characters of
Well, in those comments, she was never mentioned by name.
Geez, I'm almost inclined to put in a data subject matter request to you now. Like, what information do you have in there?
Irish confidential trading will be finished by 2.
Could I ask a question of Finín as well, being left out? It's going back to the whole question of your relevant filing system and throwing everything in a room on archived or whatever, unlisted. One of the things that I do for myself is if I have done some citing trust or citing a particular type of document that I think is going to be very useful as precedent, I set it aside and I have it in a sort of a precedent bank. I might have it on the computer, I might have it in paper form. I don't anonymise it because, to be honest, it's usually in my head. I remember I had that client and this is how I remember to get back that trust deed or that particular thing. It's not on a client file, it's not archived under the client name, so therefore if I have my temporary, my temp going in looking for that person, they won't find that individual's personal data in a filing system under precedence. If I told them to go and find that trust, go find a trust that deals with special needs, they would go and they would find and they would see the personal data in the trust. So in other words, I haven't filed it under the personal data, they are not identified in that way. Can I avoid having to anonymise all of my precedents is really what I'm trying to get at.
And so just how do you find it then?
Memory. And also certain keywords. And then I will remember that a particular client had a surname. But they're not filed under the client name, they're filed under my precedent files.
And is this all hard copy or is it electronic?
Both.
So the throwing everything into a room scenario only applies with hard copy stuff. If it's anything held electronically, it's called.
Okay, because you could actually do a search against the name. Yeah.
So if you wanted to keep precedents, all I could put it might be as simple as redacting out their name in your precedent
It's
bank.
not as simple when you have a precedent bank that goes to
and
a couple of rooms.
And then just to annoy you, Aileen, you can only hold on to information for as long as it's necessary. So if this is a file that's been closed off for 10 years, you really shouldn't be holding that personal data on that individual anymore.
Shred and start again.
So it's no longer simply.
Well, if it's a trust.
Absolutely, and if you can say I have a need to hold on to this, that's fine. But as soon as you stop having a purpose and it's no longer necessary to hold that data, you have to delete. To be honest, it's beneficial to delete older information because if you get a random data subject expert out of the blue, you don't have to deal with it then.
So we like tricky deeds of assent and stuff like that would have to anonymise because there wouldn't be any justification to keep them beyond 12 years. But trusts, yes, you can keep the lifetime of the trust.
Okay, well, we might let maybe one final question and then maybe.
Just in terms of children especially vulnerable situations, families are changing and you see different situations developing. Sorry. I suppose families are changing the feedback there. I come across situations where you see legal guardians, your grandparents, or a family member looking responsible for a child, in foster child situations where factor members of the family. I had a situation a couple of years where someone was very successful and had a very, very, was independently wealthy, had a foster child which became their de facto child, a member of the family down the line. But is it always the case that it's wise to consider legal adoption at a certain point when a child is under 18 because it enhances the provision that you can make that more tax provisions for the family in an overall context? Or what's your experience with regard to legal adoption, foster children, guardianship rights? Is it always wise to consider that when effectively that child will be a long-standing member of the family and would conceivably have the same inheritance slice of the family of the estate as
I don't have particular experience in that situation, but I just know isn't the legislation such that they can actually fall into the Class A threshold anyhow. So whether they're adopted or whether they're
I
fostered.
understand that you can only legally adopt somebody once they're minor, and it's effectively legally adopted
Once they turn 18.
Once they're 18.
Okay.
Yeah.
If they're fostered, yeah, the foster is there for that purpose, so that even if you haven't adopted, you're still a Class A threshold for a foster. I think that covers. Section 117 claims, I don't think are available. You have to be a child. So if there's that issue, but then if you're not leaving that child anything, chances are you wouldn't be recommending that they be adopted so that they can claim against you later. So that's the logic on that one. But I don't see any other particular nuances there. Guardianship, I'm not sure of. I would have thought if you're a foster parent, you don't have a right to appoint a testamentary guardian. Or do you? I don't know. I would have thought that you'd have to go back to Tulsa or whatever and deal with them. They would be the ones who'd be dealing with it.
Class A says the person's a local parentis. It does.
Class A does, yes. Yeah, that's what we're saying, that you don't necessarily have to have adopted, that you would fall in under the Class A threshold anyhow.
Thank you all. We might break now for lunch, which is in the bistro, which is over towards reception, and we'll come back again for 2 o'clock and we'll wrap it.